You are listening to the global network of podcasters dedicated to the pharmacy profession. Welcome to the Pharmacy Podcast Network.
You're listening to the NASP Specialty Pharmacy Podcast, a collaboration between the National Association of Specialty Pharmacy and the Pharmacy Podcast Network. Each episode dives deep into trends, challenges, innovations, and patient-centric practices shaping the future of this dynamic and rapidly evolving industry. Whether you're a pharmacist or healthcare provider, patient advocate, or industry leader, you'll hear expert insights, real-world evidence, and thought-provoking discussion that highlights all that makes specialty pharmacy special.
In support of NASP's mission to empower specialty pharmacy stakeholders to advance the standard of patient care, NASP supports a free market healthcare system in which all specialty pharmacies compete on the same fair and level playing field, because that is in the best interest of the patients we collectively serve. NASP is committed to working with all stakeholders and policymakers to ensure that all patients have access to the life-saving medications they need and the high-touch patient care and support services they deserve from the pharmacy of their choosing.
Hello, my name is Sheila Arquette, and I am the President and CEO of the National Association of Specialty Pharmacy. I am delighted to welcome two very special guests, Jonathan L. Swisher and Bradley A. Wasser, to this episode of the NASP podcast. Jonathan Swisher is chair of the Duane Morris Pharmacy Litigation Group and a member of the firm's Governing Partners Board. For more than 25 years, Mr. Swisher has represented thousands of independent pharmacies and healthcare providers in regulatory, civil, and criminal proceedings. His practice is dedicated to representing all provider types throughout the United States, including specialty pharmacies, mail-order pharmacies, retail pharmacies, compounding pharmacies, home infusion pharmacies, telehealth pharmacies, hospital pharmacies, home care pharmacies, long-term care pharmacies, oncology pharmacies, among others. He has handled thousands of matters on behalf of such providers involving all aspects of their business operations, including, but not limited to, issues with payers and pharmacy benefit managers, PBM audit appeals, challenges to network terminations, refusals to provide network access, and in the submission of credentialing applications. Bradley Wasser practices in the area of litigation with a focus on private antitrust and business counseling and government advocacy. Mr. Wasser has experience with providing a wide range of legal, regulatory, and business advice for national associations of healthcare providers, individual healthcare providers and pharmacies, beer wholesalers, retailers, and high technology firms. Mr. Wasser is a member of Duane Morris's Pharmacy Litigation Group. He represents healthcare providers, including pharmacies, in disputes with insurance companies and pharmacy benefit managers, ranging from audits to network participation rights to termination of providers from insurance and pharmacy benefit manager networks. Jonathan and Brad, thanks so much for joining me today.
Well, thank you, Sheila, for giving us this opportunity.
Yeah, I was going to say the same thing. It's great to be with you, Sheila.
So I understand over the past year, state legislatures have taken the lead in providing greater protections to non-PBM affiliated specialty pharmacies. Give me an overview of the ways in which states are trying to make things easier for specialty pharmacies.
Sheila, it's an excellent question. I'm sure one that's of significant importance to many NASP members. As you noted in the introduction, I've been doing this for about 25 years, and PBMs have been around since the 1960s. Really wasn't until about 5 years ago when the U.S. Supreme Court, in a decision in the case of Rutledge versus PCMA, took on, for the first time in a fairly public manner, an issue as to whether a law that the state of Arkansas passed to regulate PBMs within that state was constitutional, that society in general really began to understand who PBMs are, what they do, the extent to which they influence whether individuals with insurance are able to receive certain medications and the extent to which they influence the ability of pharmacies that are not affiliated with PBMs, the large chain pharmacies, are able to stay in business. When the U.S. Supreme Court in the Rutledge case issued an opinion and order holding that a law that Arkansas passed requiring that PBMs provide a certain minimum amount of reimbursement to independent pharmacies in that state, it was really the first time any authoritative body made clear that pharmacy benefit managers had, in certain instances, gone a little too far with regard to the way in which they were doing business with pharmacies. They were making it very difficult for pharmacies to stay in business, and there really was a need for reform. Almost immediately after the U.S. Supreme Court held that the Arkansas law, which was called Act 900, was lawful, it gave rise to dozens of other states, which likely had heard similar complaints over the years from pharmacies in their states, introducing bills and pretty quickly passing laws that are analogous to the law at issue in Arkansas to more aggressively regulate pharmacy benefit managers and provide certain protections to pharmacies, which really for decades they had said were critical to their existence. So over the past year, we probably have seen laws evolving on a state level at a pace we haven't seen over the past 30 years. And with regard to the laws that are being passed on a state level, let me just offer up, I guess, some high-level observations, and then Brad can follow up with perhaps some additional specifics. First, it's important to note that states are able to regulate commercial insurance plans. They are not able to regulate employer plans. Employer plans are within the purview of ERISA, and ERISA preempts any attempts by the state to regulate insurance. States also do not have the ability to regulate Medicare plans. So with regard to commercial insurance, the states have authority to regulate, and the main, I would say, categories that states have passed laws within the last year fall into the following categories. First, states are, with increasing frequency, becoming any willing provider states. Any willing provider, as you know, is a concept that derives from Medicare Part D. It says to a PBM or an insurance company that if a pharmacy is able to comply with fair and reasonable terms to participate in a network, you have to give them an opportunity to demonstrate that they can do so. You can't exclude them from participating from that network if they're able to satisfy your terms and conditions. So any willing provider is not only important for Medicare plans, it's obviously important for the commercial plans that insurance companies have that are being administered by PBM. So we've seen additional states become any willing provider states. We've also seen states that I would say for years were somewhat reluctant to become any willing provider states adopt the network adequacy requirements of Medicare. The network adequacy requirements of Medicare essentially say to insurance companies and PBMs that if you want to participate in a particular network, you need to ensure that there is a brick and mortar pharmacy within a certain number of miles of the insurance plan, the insureds and their members of the PBM. Otherwise, you need to allow pharmacies within the requisite mileage participate. So there are certain states which over the last year have elected not to become any willing provider states, but instead have stated that PBMs and insurance companies, if they want to do business in that state, must agree to comply with the Medicare network adequacy requirements. And because the mileage that those requirements say the PBMs and insurance companies must ensure, the insureds will have access to a brick and mortar pharmacy in terms of the distance from their home, it almost has converted those states into any willing provider states, because you can't force individuals any longer, as PBMs and insurance companies have been doing for quite some time, to obtain their medication via mail. They need to obtain medication really just within a few miles of where they live. And that's where the independent pharmacies, the pharmacies that are not the large retail chain pharmacies, become relevant. In addition to network access, a number of states over the past year have, like Arkansas, implemented laws with regard to minimum amounts of reimbursement that PBMs are required to provide to those pharmacies when they fill medications for their members. The general trend is, at a minimum, they must reimburse the pharmacies at the NADAC amount to the extent that a NADAC amount is published. If a NADAC amount is not published, then most states say that you can't reimburse the pharmacy below its wholesale costs. Far too long, pharmacies have complained about being forced to accept PBM agreements that would reimburse them below their costs, thus imposing losses on the pharmacies. And we've seen quite a few pharmacies now be able to alleviate those problems, because the states have now required reimbursement at a minimum, no less than what their actual costs are. I would say another category of laws that we've seen over the last year or so, which is pretty relevant to most pharmacies, is the fact that for quite some time, PBMs would limit the ability of pharmacies to mail medications. They would either limit the percentage of overall fills that could be mailed, or they would say that you can't mail unless you are within a particular PBM mail network. Getting into those networks had for quite some time been very difficult, required certain accreditations that could be fairly costly for an independent pharmacy. A number of states within the last year have made clear, recognizing, particularly following COVID, when mail to customers became commonplace, that in this day and age, individuals are a lot less likely to go to a pharmacy to get their medications. Pharmacies mailing medications to their customers is something that can be done properly and safely. And therefore, they passed laws essentially telling PBMs or insurance companies doing business in that state, you cannot penalize pharmacies for mailing medications. Therefore, the requirement that pharmacies be admitted into a mail network if they want to mail, those requirements are now going by the wayside. Attempts by certain PBMs or insurance companies to limit the overall percentage of mailings that a pharmacy would engage in would likewise run afoul of a particular state law. So pharmacies are now allowed to mail in a way that up until, I would say, about a year or so ago, they didn't have the freedom or the ability to do. So those are, just off the top of my head, a few fairly significant reforms that we have seen on a state level over the past year, which for the pharmacies that are likely listening to this podcast really provides substantial benefit. The only other thing I will say is most of the form contracts that are being provided to PBMs or insurance or by insurance companies to the pharmacies are not taking into account the somewhat recent changes with regard to state laws. And therefore, if you are a pharmacy owner or executive, it truly is imperative that you are reviewing closely the contract that you are receiving to make sure that that form contract is taking into account any changes that may have occurred in your state, because the majority of the contracts that we are seeing that are being proposed to pharmacies are not incorporating the way in which the laws of that state have changed within the past year.
Yeah, and I agree with Jonathan that these are the highlights coming out of this most recent state legislature, passed bills. One piece that's really interesting, and just to go back into it, is the whole mail related issue. And I think it's particularly important for, the non-affiliated specialty pharmacies who, as we all know, who are in this world, often have access to certain limited distribution drugs that are not carried by your regular retail pharmacies or your corner pharmacies. So it's important that specialty pharmacies, particularly non-affiliated specialty pharmacies, have access to be able to deliver medications to those patients who need medications filled that they can't otherwise access via regular retail channels. So when we see limitations that PBMs had placed for years on the ability of specialty pharmacies to mail medications, particularly, and this is my cynical nature coming through here, when a lot of it, Sheila, you might recognize, I think has been done for particularly competitive reasons, to give those PBM affiliated specialty pharmacies an advantage to be able to access more customers than, say the non-affiliated specialty pharmacies may be able to do. To me, this is one of the most important provisions that we're seeing coming out of state laws recently. And I think, also just to sort of piggyback on another point that Jonathan raised, with respect to certain reimbursement levels that we're also seeing, from our perspective, and we can get into this a little bit more, this is really designed with the goal of allowing pharmacies to now recoup at least the costs that they've paid for medications, because as we know, over the years, there's been a significant downturn in reimbursement rates that pharmacy benefit managers have paid to pharmacies, to the non-affiliated pharmacies, and as medications become more expensive, we see that, there really are variations in pricing. And I think, having these, what they call NADAC, the National Acquisition Costs, or wholesale costs being implemented into state law and effectively requiring PBMs to guarantee that minimum reimbursement, it really will allow independent specialty pharmacies or not affiliated specialty pharmacies, to better plan for, the longevity of their businesses, help take care of their patients, effectively help plan, for everything that they can do to best serve patients in need of specialty medications.
So I also understand that there are efforts being made at the federal level to improve conditions for non-PBM affiliated specialty pharmacies. Let's talk about that a little bit. Can you provide some examples of what the federal government is doing?
So on a federal level, couple of years ago, the FTC, which had been asked by pharmacies for quite some time to study the way in which PBMs were doing business with them, finally decided.
John, I'm going to interrupt you just so the pharmacies listening know, and I know everybody's very familiar with this. I just want to make clear when we talk about FTC, we're referring to the Federal Trade Commission, just so people aren't saying, oh, well, what is that acronym? I'm not in Washington, so I don't understand all the ABCs. I just wanted to make that clear. So sorry, John, go ahead.
So the FTC finally agreed to move forward with what's called a 6B study. And the purpose of the 6B study, and this occurred during the Biden administration, was to assess to what extent, if at all, the three major PBMs were engaged in what's called unfair trade practices. The FTC is tasked by Congress with attempting, among other things, to identify the extent to which businesses in the U.S. are involved in unfair trade practices. Thus, via this 6B study, they have obtained from the major PBMs literally millions of documents over the past couple of years, which, as we understand it, they have devoted significant time analyzing to try to assess whether, in the eyes of the FTC, the major PBMs are acting unfairly towards independent pharmacies. Up until today, the FTC has already issued two preliminary reports. Each report is publicly available. Each report is approximately 70 pages. And over the course of these two reports, the FTC describes in pretty substantial detail the various ways in which it believes the evidence it has already obtained demonstrates that PBMs are, and again, this is the FTC's conclusions, acting unfairly towards independent pharmacies. When the FTC announced that it was moving forward with this study, it gave rise to other federal government agencies deciding that they too wanted to investigate the extent to which PBMs may not be acting fairly towards independent pharmacies. So the House Oversight Committee announced that it would be conducting almost an identical investigation to what the FTC was investigating. The House Judiciary Committee announced that it would be conducting a similar investigation. And the Department of Justice announced that it was going to create a healthcare task force, the sole purpose of which was to itself determine whether or not any of the conduct of PBMs or the insurance companies that they work with constitutes a violation of federal law, primarily the antitrust laws. So within the last year or two, nearly every federal agency that is tasked with investigating and monitoring the healthcare system here in the US has made it a major initiative to focus on the PBM pharmacy relationship. Since the administration has changed, we have not seen any of those agencies let up the investigations that were put into motion a couple of years ago. And based upon comments that have been made by representatives of those agencies, we are anticipating that certain of them will be issuing final reports by the middle of this year. When those final reports are issued, it will give rise to some fairly significant developments on multiple fronts. So, for example, the FTC has the ability to bring enforcement actions against any entity it believes is involved in unfair trade practices if their final report is consistent with the preliminary reports that they've already issued. The FTC would then have enforcement authority against the PBMs that they believe are involved in unfair trade practices. The FTC would then share that information with the DOJ, which has made clear that via this healthcare task force, it's going to move forward with complaints against PBMs. The information that all of these government agencies have been eliciting also is being closely watched by members of Congress. And based upon the reports and other information that these agencies have issued over the last year or so, some fairly meaningful bills are now being introduced, bipartisan bills, which, if they're able to make their way through Congress, would lead to laws that are very similar to certain of the laws that I summarized before on a state level. So on a federal level, this could be a relatively active year in terms of investigations and studies starting a couple of years ago coming to a conclusion. I'll pause there and give Brad an opportunity to jump in and add anything else that he wants to contribute.
Yeah, so I obviously believe that's a great overview, John, as to what's happening on the federal level. But interestingly, to your point too, not just Congress, that's watching the actions that are coming from some of the agencies, but and not to go back to the state level too much, but I think it's also worthy to note that at the state level, the various state attorneys general are also paying close attention to what's coming out of the federal government, as well as what's happening in their individual states. We've seen a number of studies, done in Ohio and Michigan, Pennsylvania over the years, also sort of piggybacking on potential unfair trade practices or unfair methods of competition that the Federal Trade Commission has been focused on. And we've seen a couple of lawsuits that are now stemming from various state attorneys general. I think Michigan was the most recent state to bring a lawsuit concerning various drug pricing practices in which the pharmacy benefit managers are engaged in. Also coming out of the Federal Trade Commission recently was a lawsuit that the Federal Trade Commission filed, during the pendency of its 6B study, John, that you discussed, regarding the PBMs and their affiliated group purchasing organizations for engaging in what the FTC deemed to be anti-competitive and unfair rebating practices that have led to artificially inflated list price of certain types of medications. So I think there's some. So first of all, the general issues that the federal government is looking at in terms of, potential competition or pharmacy benefit managers inhibiting competition from non-affiliated pharmacies, is very interesting to watch. But I also think there are some particularly discrete issues like drug pricing issues, et cetera, that Congress and certain state attorneys generals are paying close attention to. And John and Sheila, I'm sure both of you recently saw out of the most recent House Judiciary Committee hearings, that they followed up to certain PBMs with requests and regarding practices over what's called, hub pharmacy practices, wherein, you'll have a manufacturer who has a specific drug, usually a limited distribution type drug, often a specialty drug, that they have a select network of pharmacies that every time they receive a prescription, they're able to, have a pharmacy that has access to those drugs fill the medication on behalf of a patient and then ship those medications out to those patients. For years, certain pharmacy benefit managers limited the opportunity for pharmacies to participate in those hubs, which afforded more access and do afford more access to individuals to obtain necessary specialty medications. So that's an area that Congress is looking at, particularly the House Judiciary Committee. So I think coming out of the federal government's scrutiny over recent pharmacy benefit manager conduct is hopefully going to be beneficial as we move through the year for the non-affiliated specialty pharmacies that we deal with day in and day out.
So separate from state and federal government action, I understand that courts have recently been asked to assess whether certain actions to protect non-PBM affiliated specialty pharmacies are lawful. Can you summarize some of those developments?
So, Sheila, that's a very timely question. We mentioned earlier the Rutledge case, and the Rutledge case was the first case in the history of American jurisprudence to go to the U.S. Supreme Court that involved issues arising out of the PBM pharmacy relationship. As we speak, there is another case that is at the U.S. Supreme Court level that potentially could be even more significant for the industry than Rutledge. And the case arises out of a law that the state of Oklahoma passed to regulate PBMs. The law that Oklahoma passed was more expansive than the law at issue in Arkansas. And whereas Arkansas really focused on the permissibility of requiring that PBMs and insurance companies reimburse pharmacies at a minimum level, the Oklahoma law delved much more into the parameters of any willing provider laws. Mm-hmm. So the Oklahoma law is dictating to PBMs and insurance companies the circumstances in which they are required to allow pharmacies to participate in their networks. And there are 4 aspects of that law. I won't, for purposes of time, go into each category, but 4 aspects which the PBMs and PCMA, the lobbying group that the PBMs work with, have claimed violate ERISA as well as certain other laws. The case, when it went up to the Federal Court of Appeals, held that the Oklahoma law was unconstitutional because it violated ERISA. The Attorney General's office that in Oklahoma filed with the U.S. Supreme Court a petition for certiorari, asking the U.S. Supreme Court to consider the appropriateness of the decision rendered by the Court of Appeals. The briefing just within the past week has concluded, and there were some interesting developments in the petition for certiorari process that you do not typically see. So the U.S. Supreme Court, as part of its decision as to whether to hear the case, asked that the U.S. Solicitor General submit a brief as to whether it thought that the U.S. Supreme Court needed to reconsider the Court of Appeals decision. There also was an amicus brief, which is a brief that is filed by a third party that has an interest in the matter, that was filed on behalf of a number of state attorney generals on the issues regarding the case. As of today, when this podcast is being recorded, we understand that the U.S. Supreme Court will be making a decision within the next couple of weeks as to whether it will agree to hear the case If it does agree to hear the case, that case could have some pretty significant ramifications that go beyond the issue as to whether the Oklahoma law in and of itself is lawful. Again, what is at issue in Oklahoma is an any willing provider law. And any willing provider laws have, for a number of years, been critical for pharmacies, as those laws, as I mentioned earlier, require that PBMs and insurance companies give pharmacies an opportunity to participate in a network. For pharmacies that are not in states that are any willing provider laws, there really is nothing prohibiting PBMs or insurance companies from telling those pharmacies when they want to participate in a particular network that the network's closed, that at that point in time, they're not looking to add new pharmacies to the network. So it was really the creation of any willing provider laws on a state level, again, deriving from the any willing provider principles found in Medicare Part D, that gave pharmacies the opportunity to participate in commercial plans that they were being excluded from for a number of years. So if the U.S. Supreme Court agrees to hear the Mulready case, it is very likely that as part of its analysis as to whether the Oklahoma any willing provider law is appropriate, it will delve a little bit deeper into the question as to whether any willing provider laws in general are appropriate. Now, without getting too detailed into areas of the law that can be somewhat complicated, the main issue that exists nationally arises out of laws that do not specifically exclude either ERISA plans, which again are employer-sponsored plans, or Medicare plans. The question as to whether or not a state can regulate Medicare, that's easily answered. A state cannot do that. As for ERISA, the law becomes a little bit more gray, and courts have disagreed as to whether any willing provider laws that would require that a PBM allow a pharmacy to participate in a network when that network involves employer-sponsored plans runs afoul of ERISA, and therefore the law would be preempted by ERISA. If a law is preempted by ERISA, again, it's not lawful. So in anticipation of the U.S. Supreme Court hearing already, some of the states that I referred to earlier, which over the past year have expanded their laws to implement any willing provider principles within their states, have specifically stated when their laws were passed that their any willing provider laws do not apply to ERISA plans, do not apply to Medicare, but there still are a number of states that have had any willing provider laws on the books for years that have not explicitly carved out ERISA or Medicare-based plans. So if the U.S. Supreme Court takes the case, and if the U.S. Supreme Court were to decide that any willing provider laws are legally valid so long as they do not apply to employer-sponsored plans, which again is covered by ERISA, or Medicare plans, it's going to likely force a number of states that have not yet specifically carved out those types of plans from their any willing provider laws to amend the laws on the books. And if they do not proceed to do so, like PCMA, which is the lobbying group for the PBMs, have done in Arkansas and with Oklahoma, they will likely proceed to challenge any willing provider laws in other states, which again, for pharmacies that are not affiliated with the PBMs, has really been essential to their ability to remain in business. So the case, if accepted by the U.S. Supreme Court, will likely become the most significant judicial matter to involve the pharmacy industry.
Yeah, and I'll just second what Jonathan said, and I think you articulated things very well, Jonathan. I mean, from just a practical standpoint, from these cases that, come out of the Supreme Court, I think states and state legislatures often look to see, or will be, at least in the case of Rutledge, they did. And I think whatever comes out of Mulready, to the extent that the Supreme Court ultimately decides to hear the case or not, is state legislatures paying specific attention to how they can amend laws to basically fit within the parameters that the Supreme Court will ultimately come down with. So that is an extremely important, the Mulready case, an extremely important case to keep our eyes on, as we move forward in the next couple of weeks. But I think we might be remiss too if we don't just mention, and we don't have to specifically delve into it, another a pair of lawsuits that was recently filed at the very end of May. So they're extremely timely because they also touch on certain laws. Well, one particular law that one state has passed and that other states are considering, and that is Arkansas's sort of first of kind law, wherein the state decided to ban PBM ownership of pharmacies within that state. There's been major pharmacy benefit managers as a result of that law that have filed lawsuits arguing that those law, particularly the Arkansas law, is not constitutional. That it violates certain aspects of the Constitution, and what's interesting is the theories that are being asserted by the pharmacy benefit managers, whereas one major pharmacy benefit manager only talked about constitutional or potential constitutional violations, whereas another pharmacy benefit manager who filed a companion lawsuit also has raised an ERISA issue, John, which we know, and as you articulated, is, sort of at the heart of both the Rutledge case back in 2020 and the Mulready case that's currently being reviewed. So, it's going to be fantastically interesting to see what comes from these cases and, whether or not those more, I would say, controversial laws like the law passed in Arkansas and those that, some other states are considering, to see what the courts might say, as to whether or not those laws, will be or are able to be valid on a going forward basis.
So there was a fair amount of anticipation as to how non-PBM affiliated specialty pharmacies may benefit or lose protections once Trump became president. Even though he has only served for less than 5 months as of this podcast recording, can you provide some opinions as to whether the change in administration has helped or hurt specialty pharmacies?
So this was something in early January that in our practice really was a frequent topic of discussion. The fact that on day one, Trump issued executive orders revoking executive orders that had previously been issued by President Biden that appeared to be for the benefit of independent pharmacies that were focused on lowering drug costs back in January caused some anxiety among independent pharmacies and their customers as to whether the initiatives that were put in motion by President Biden to reduce drug costs, to ensure that the momentum independent pharmacies had been benefiting from with regard to getting into PBM networks, being fairly reimbursed, et cetera, would continue. But if we look at the executive orders that have been issued since that mid-January timeframe, we take at face value comments which have been made by President Trump, members of his administration, members of his family, and also the comments most recently made with regard to what President Trump considered to be mandatory requirements with regard to the pending big beautiful bill. Everything as of today continues to suggest that the Trump administration is very, very focused on keeping costs down for medications, but at the same time ensuring that pharmacies continue to be reimbursed fairly, regardless as to how those costs are impacted. So we've seen nothing among any of the government agencies that I identified before on a federal level suggesting that they are reconsidering or deviating from the work that was done by those agencies before Trump became president. When states are passing laws that are similar to the laws that I mentioned earlier, members of those federal government agencies are issuing statements approving of those laws. And just last night, when a Louisiana law that was anticipated to be passed that would have precluded PBM affiliated pharmacies from doing business in Louisiana was struck down, President Trump's son, Donald Trump Jr., immediately issued a statement expressing his disappointment that that law was not passed. So, with regard to what was considerable momentum over the past couple of years on both a federal and state level to provide certain protections to independent pharmacies, that momentum has not appeared to have been disrupted over the last 6 months. And while the focus with this administration is primarily going to be on keeping costs down for individuals with regard to the drugs that they require, so long as accompanying that focus is a focus on making sure that whatever the costs are, the pharmacies that are stocking and dispensing them are being reimbursed appropriately. As of today, we have no reason to believe that things will become any less favorable for independent pharmacies. And I think once we see the final report from the FTC, final reports or notices from the House Oversight Committee and the House Judiciary Committee, and then we see how the DOJ moves forward in response to all of the evidence that's being gathered by these government agencies and committees, pharmacies will be able to be even more confident that the change in the administration will not disrupt what really has been substantial improvements for their operations over the past couple of years.
Yeah, and I certainly agree with that assessment, John. I also think that it's interesting to see that, and not just interesting, but I think it's fortunate to see that there is. Um, I would term it a sharing of goal across administrations, coming out into the Biden administration, into the Trump administration, that there's a desire to see healthcare prices and drug prices in general decrease. Obviously, with the decrease in cost of drugs, there could be impact to, reimbursements that are provided to the pharmacies that are dispensing those medications. But John, to some of the points that you made, I think with a focus on price protection and other protections for pharmacy benefit managers, the goal, through the Trump administration, as well as the various actions coming out of the numerous federal agencies that are looking into this and actively engaged in this space, are hopefully those continued protections of pharmacies, and because of that, all the studies that are occurring, the language that's being proposed in numerous bills that Congress is looking at, including the one big beautiful bill, or the reconciliation bill that is now going to be looked at by the Senate. All of that's to say that I am glad to see, parity across administrations with the goal of trying to keep prices down for consumers, yet at the same time, try to protect the independent specialty pharmacies or non-affiliated pharmacies. Um, in the goal of having their longevity protected, as well as the ability to be able to be profitable in business and to properly service the customers that are in need of specialty and other medications.
Well, awesome. Thank you so much, Jonathan and Brad, for chatting with me and sharing all of this valuable information.
Well, thanks, Sheila. It's certainly our pleasure, and we're happy to do this anytime. We could get a weekly podcast going if you want. There's plenty to talk about these days. As like we said, bills are not just bills, but things are coming out at a weekly clip, so it's often hard to keep up with the pace.
Yeah, thank you, Sheila. We appreciate the opportunity.
Of course, of course. As a reminder, NASP corporate members are invited to be my guest on one complimentary podcast per year. For more information about this or other NASP membership benefits and events, please feel free to reach out to membership at naspnet.org or visit our website, www.naspnet.org. Until next time, have a great day.